My daughter-in-law tore up my grandson's painting on a Tuesday afternoon in March, and I was in the kitchen when I heard the sound of it, the specific tearing sound of heavy paper being separated along a grain that does not want to be separated. And I did not go into the front room immediately, because I was finishing my tea, and because there are moments when a woman of 83 does not go immediately to the sound of breaking things, because she knows that some things, once broken, require more than physical presence to address. The painting had been on the wall of the front room since September, when my grandson Noah had made it for me. He was 8 years old, and he was in a period of making paintings with the specific focused energy of an 8-year-old who has found something that produces results proportional to effort, which is the discovery that sends some children toward art for the rest of their lives. The painting was of a house, not any particular house, but the house that exists in the specific imagination of an 8-year-old who is thinking about what a house should be. A big front door, windows with square panes, a garden with flowers that were large relative to the house because they were important to him, and in the upper left corner, a yellow sun that had been given rays of the kind that suns in children's paintings always have, which is to say 8 rays of roughly equal length emanating from a circle. It was not a sophisticated painting. It was exactly what it was, an 8-year-old's painting made for the person he loved most, given with the complete intention of a child who understands that giving something he made is different from giving something he purchased, and that the difference matters. He had given it to me at my birthday in September, and he had said, handing it over with the careful ceremony of a child who has decided a gift is important, "Grandma, I made it so you'd have a house when you need one." He was 8 years old, and he had some understanding, the child's sideways understanding, that his grandmother's situation in his parents' house was not entirely comfortable, and that she might someday need a house of her own. I had framed it in a simple wooden frame from the craft store, and I had hung it on the wall of the front room, in the place where the light from the window caught it in the mornings, and I had looked at it every morning since September with the specific pleasure of someone who has been given something that is precisely right. Behind the frame, between the back of the canvas board and the backing paper, was the document that had been there since the day before I hung the painting. Clarissa, my son Patrick's wife, my daughter-in-law for 22 years, had been in the front room when she tore it. I heard it from the kitchen. I finished my tea. I went to the doorway. She was holding pieces of the painting, not small pieces. She had torn it in a rough diagonal and then torn each half again, so there were 4 irregular sections of the heavy paper. The house was distributed across 4 pieces. The sun was in one of the sections. The flowers were divided. "These rubbish drawings dirty the walls," she said. She said it the way she said most things that she said to me, with the particular quality of someone who knows she has more power in the room than the other person, and who exercises the knowledge without being required to justify it. "I have guests coming Thursday. The front room needs to look like adults live here. Noah made that painting," I said. "Noah is 8 years old," she said. "He can make another one." She put the torn pieces on the side table. She left the room. I went to the side table. I looked at the pieces. I looked at the wall where the frame had been, and where the pale rectangle of unfaded wallpaper now showed against the slightly darker surrounding. I picked up the pieces and I held them for a moment, and then I put them in the chest in my bedroom, in the bottom drawer under the winter sweaters. Not because I believed the painting could be repaired. It could not in any way that would restore it to what it had been, but because what Noah had made deserved to be held rather than thrown away. And because some things, even when broken, are still what they were. My name is Edith Marion Caldwell Prescott. I am 83 years old. I was a paralegal for 26 years, and I know how legal documents work, and I know how wills work, and I know what the will behind the painting said, and I had known from the moment I put it there that what mattered was not the document itself, but what would happen to the document when the time came. The time was not yet, but the condition of the will had been met, in the specific way it had been written to be met, which was a way that required no additional action from me. Clarissa had met it herself. I want to explain the will before I tell you the story of the painting's creation. because the will is the technical center of the story, and because understanding it requires understanding how a paralegal who has spent 26 years in the company of estate attorneys thinks about documents. A will is, at its core, a document that specifies how a person's property is to be distributed after their death. The distribution can be conditional. That is, the will can specify that property goes to person A if condition X is met, and to person B if condition X is not met. Conditional bequests are common in estate law, and they are entirely enforceable provided the conditions are specific enough to be verifiable and do not violate public policy. The will I had prepared, with the assistance of my former employer, an estate attorney named Catherine Marsh, who had been my supervising attorney for 12 of my 26 years as a paralegal, and who owed me, in the way of professional relationships where one person has been genuinely indispensable, the specific favor of drafting a document with unusual conditions without requiring extensive justification, contained the following provision, which I will reproduce exactly because precision matters in legal documents. The residential property at 4421 Chestnut Drive, Columbus, Ohio, together with all contents thereof, is devised as follows. If the painting given to the testator by her grandson, Noah Patrick Caldwell, Dobelwell, September 14, 2015, at the testator's birthday celebration in September 2023, is found to be intact and in the possession of the testator's household at the time of the testator's death, said property shall pass to the testator's daughter-in-law, Clarissa May Caldwell. If the painting is not found to be intact and in the possession of the testator's household at the time of the testator's death, whether through loss, destruction, sale, or any other means, said property shall pass in trust to Noah Patrick Caldwell, to be administered by the Franklin County Children's Services Board until the beneficiary reaches the age of 25, with the trustee having the authority to use trust income for the beneficiary's education and welfare. The will had been executed in August 2023, 1 month before Noah's birthday. I had kept a copy with Catherine Marsh's firm, a copy in my own lockbox at the bank, and a copy in the specific location that I want to describe now. The copy behind the painting was the original, signed in original ink, witnessed by Catherine and her associate, the document with legal primacy in the execution of the estate. The bank copy was a notarized copy. The firm's copy was the master file. I had placed the original behind the painting for a specific reason. I wanted the painting to protect the will, not in a metaphorical sense, in the literal sense of a document that needed to remain undisturbed, and that would be disturbed by anyone who moved or damaged the painting it was housed behind. If the painting was intact, the will behind it was intact. If the painting was destroyed, the will behind it would be damaged or destroyed as well, and its condition would be discoverable by the attorney who would examine the estate at my death. The condition of the will at my death would tell the attorney something about what had happened to the painting, and what had happened to the painting would determine which bequest took effect. I want to be precise about something. I had not designed the will to punish Clarissa. I had designed it to protect Noah. These are different things. The protection of Noah required a structure in which the people who had legal control over the estate's assets were given a specific incentive to protect the thing Noah had given me, because the protection of that thing was the protection of Noah's interest, his interest in having a grandmother whose most treasured possession was a painting he had made, and his interest in the eventual inheritance. The structure I designed was one in which Clarissa's incentive to protect the painting was identical to Noah's interest in having it protected. If Clarissa was the person she wished to present herself as, a person who valued her household stability and her son's well-being, she would protect the painting because protecting it served her interests. If Clarissa was the person she was in the private space of her house, a person who regarded my presence and my grandson's painting as irritants to be managed, she would destroy the painting and inadvertently transfer the property. I had not known which would happen. I had designed the structure so that either outcome was acceptable from the standpoint of the estate's ultimate distribution. Noah's well-being was protected either way. In the good outcome, the painting was safe and the property passed to his parents' household where he lived. In the less good outcome, the painting was destroyed and the property passed to a trust in his name. The less good outcome was, I had concluded after careful thought, actually the better outcome for Noah in the long run. A trust in his name, administered by a professional trustee, with assets designated for his education and welfare, was more reliably in his interest than a property that passed to his mother's control. I had not shared this conclusion with Catherine Marsh because Catherine did not need to know it to draft the document. She had asked whether the conditions were likely to be verifiable. I had said yes, and she had drafted accordingly. Let me tell you about Noah before I tell you about the rest, because Noah is the reason everything I did was worth doing, and the reason deserves to be named fully. Noah Patrick Caldwell is 8 years old. He was born in September 2015, the second child of Patrick and Clarissa. And he is the specific kind of child who reminds you, if you have spent enough time with children, that people arrive in the world with their own distinct natures, that the person is there from the beginning, in the specific combination of temperament and curiosity, and the particular way of engaging with the world that no amount of parenting produces or prevents. Noah's nature is quiet and observant. He watches things before he engages with them. He asks questions that are not the standard questions, not the questions that are really requests for social connection, which is what most children's questions are, but the questions of someone who genuinely wants to know. He had asked me once when he was 6 and we were sitting in the garden, "Grandma, why do things get old?" And I had said, starting with the biological explanation, and he had said, "But why does old happen to things at all? Why don't things just stay?" And I had thought about this question for longer than he expected me to think about it, because it was worth thinking about. He is also deeply loyal in the specific way of children who pay attention. He notices when people are not comfortable, and he does what he can do to address the discomfort in the way available to an 8-year-old, which is the way of physical presence and small gestures. He will bring a glass of water to a person who looks tired. He will sit beside a person who is alone and not say anything, which is sometimes the most effective form of company. He knows that his grandmother is not fully comfortable in his parents' house. He has known this since he was old enough to read the room, which in Noah's case was approximately 5 years old. He does not know the specifics, the tensions about money and about my ongoing presence and about the question of the estate that has been the background noise of the household since my husband Harrison died in 2018 and the house on Chestnut Drive became the estate that everyone was thinking about and no one was directly discussing. He knows the shape of it without knowing the content. The painting was his response to the shape of it. He had made it in August 2023, after a long summer weekend during which he had apparently observed more than I had noticed him observing. He had worked on it privately. His mother found him working on it twice and had asked what he was doing, and he had said he was making something for Grandma's birthday, and she had said nothing further because she has never known what to do with Noah's private projects, and she has learned to leave them alone. He gave it to me at my birthday gathering in September. Not a party. Going through necessary motions and who does not want the motions to be legible as such. Noah had been at the table and had waited until after the cake, which is the correct order of operations for significant announcements, and then he had produced the painting from under his chair. He had hidden it under his chair, which is as careful as an 8-year-old hiding can be. "Grandma," he had said, "I made this so you'd have a house when you need one." The table was quiet in the specific way of tables that have just heard something said by a child that contains more truth than the adults at the table were prepared to receive. Patrick had looked at the painting and said it was lovely. Clarissa had said something that was technically warm and emotionally neutral. I had looked at Noah across the table, and I had received the painting with both hands. The way you receive something that is genuinely offered. "This is my favorite thing," I had said. "I'm going to hang it where I can see it every morning." He had beamed with the specific satisfaction of a child who has given exactly the right thing. The following afternoon, before I hung it, I had placed the original will behind the backing paper. Harrison Caldwell Prescott and I were married in 1963 when I was 23 years old and he was 25. And we built the life that married people in the 1960s built. The house, the children, the career, the accumulation of 40 daily decisions that produce, when you look back on them, something that has the quality of a complete thing. Harrison was a civil engineer, the practical, methodical, specific kind, the kind who knew exactly what a load-bearing wall could support and who applied this knowledge to everything, not just the walls. He had the quality of someone who builds things correctly because incorrectly built things fall down, and who extends this principle to relationships and commitments and the management of the house and the household finances. He was not exciting. He was reliable, which is what I needed, and what I have always preferred to exciting. The house on Chestnut Drive was purchased in 1971, and we paid off the mortgage in 1991. And it was the house where Patrick was born and raised, and where Sarah, our daughter, who lives in Portland, and who is not part of this story except as its alternative, spent her childhood. The house has 4 bedrooms and a garden that I have maintained since 1972, and that has over 50 years become the specific kind of garden that takes 50 years to become. Not a designed garden, but a lived one. The accumulation of decisions made over decades about what to plant and where, and what to keep when the plants grow larger than anticipated. Harrison died in 2018 from a cardiac event that was, in the assessment of his physician, consistent with the cardiac profile of a man who had been careful about his diet and his exercise, and who had nonetheless the cardiac condition that his father and his grandfather had also had. He died at 80, which is a reasonable number, and he died having arranged everything as carefully as he had lived. The accounts, the insurance, the documentation. He left me the house on Chestnut Drive outright, which was as he had always intended. Patrick had been 43 when his father died. He had been married to Clarissa for 12 years by then, and they had Mira. Their eldest, 15 now, in the specific self-contained world of teenagers. And Noah was 3. Patrick is a good man in most of the ways that matter, and in the one way that has been difficult across the period since Harrison's death, which is the way of a man who loves his wife more than he is entirely comfortable with, who has organized his life around her preferences in the way of someone who mistakes deference for devotion, and who does not always notice what the deference costs other people. Clarissa had married Patrick knowing that eventually there would be an estate question, because there is always an estate question when parents own significant property and the children are watching the property with the specific attention that significant property generates. The house on Chestnut Drive is currently assessed at $340,000, which is real money in Columbus, Ohio, and which represents the most significant single asset in what Harrison left. After Harrison died, there had been a period of transition during which I remained in the Chestnut Drive house and managed it and continued my life. Then my health had shifted in the specific way that 80-year-old health shifts, not dramatically, but in the accumulation of small difficulties that make a large house alone inadvisable. And Patrick had proposed that I move in with them. I had moved in with them in 2021. The relationship between Clarissa and me had been, before the move, the relationship of a woman and her mother-in-law who interact at sufficient intervals to maintain social warmth, without sufficient proximity to require something more than warmth. After the move, the relationship had become what close proximity makes of relationships between people who have different requirements. The specific daily friction of 2 women with different standards in the same house, and the specific daily question of who this house is actually for. I had prepared the will in August 2023, not in response to a specific crisis. The crisis had been building since 2021, and would continue to build regardless of what I did, but in response to the specific clarity that 83 provides about what matters, and what does not, and what does not, and what does not, and what needs to be addressed before the addressing is no longer possible. I want to be accurate about Clarissa, because the accurate account is more complex than the simple account, and because the complex account is what is true. Clarissa May Caldwell was born in Youngstown, Ohio, in 1969, the daughter of parents who had both worked in the steel industry that was in the process of collapsing around them during her childhood, and who had conveyed to their daughter, through the specific transmission of parents who are watching their security disappear, a very serious relationship to material stability. She had worked her way through Ohio State on a partial scholarship and had graduated in 1991 and had entered the workforce with the energy of someone who is going to ensure that the instability of her childhood is never replicated in her adult life. She had largely succeeded. She was, by any objective measure, a competent person who had built a stable household and managed its finances carefully and raised children who were doing well by the metrics available to measure such things. She was not cruel in the dramatic sense. She was cruel in the specific sense of someone who has decided that her own security is the organizing principle of her life and who treats the things that threaten her sense of security, including an elderly mother-in-law who occupies a bedroom and who owns a house that should eventually belong to the household, with the managing efficiency that efficient people bring to threats. I did not think Clarissa was going to destroy the painting. I want to be honest about this. When I designed the will's conditions, I thought the most likely outcome was that the painting would remain on the wall until I died, at which point the condition would be satisfied in the ordinary way, and the property would pass to Clarissa's household, and Noah would grow up in a household that owned the Chestnut Drive house, which was a reasonable outcome. The less likely outcome, the outcome I had designed for as a contingency, was that Clarissa would, at some point, decide that the painting was a nuisance or an embarrassment or a reminder of my presence. Remove, and that she would do so without considering the implications, because she did not know the implications. She did not know the implications, because I had not told her about the will's conditions. I had not told Patrick either. I had not told anyone except Catherine Marsh, who knew the document's content and who had the professional obligation to keep it confidential. The decision not to tell them was considered and deliberate. If Clarissa had known the painting's connection to the will, she would have protected it, not out of love for Noah's artwork, but out of self-interest. And the self-interested protection would have produced the outcome she wanted while concealing the question of what she would have done if she had not known. The unknown tells you more about a person than the known. What a person does when they do not know the consequences is who they are. Clarissa in the front room on a Tuesday in March was who she was. I went to the chest in my bedroom and I took out the pieces of the painting and I looked at them. The house was in 4 parts. The sun was intact in the upper left quadrant, which was the largest piece. The flowers were distributed. I thought about what this meant for the will. The will required the painting to be intact and in the possession of the testator's household at the time of the testator's death. The painting was no longer intact. The condition of the will's primary bequest was no longer satisfiable. At my death, the attorney would inquire about the painting, as estate attorneys are instructed to inquire about specific conditions, and she would find that it was not intact, and the property would pass in trust to Noah. I returned the pieces to the drawer under the winter sweaters. I called Catherine Marsh. Catherine Marsh had been practicing estate law in Columbus for 31 years. She was 62 now, and she was, in the specific way of estate attorneys, who have spent 3 decades in the company of families navigating the distribution of what people leave behind, unflappable about human behavior. She had seen most of what families are capable of doing to each other around estates, and she maintained about these behaviors the equanimity of someone who has concluded that human nature is what it is, and that the attorney's job is to design documents that work with what human nature actually is. She had designed this document with that principle in mind. When I called her on Tuesday evening and told her what had happened, She was quiet for a long time before she spoke, which was not her typical response. Catherine's typical response is immediate and specific. "The painting is destroyed," she said. "Torn into 4 pieces," I said. "By Clarissa. I was in the kitchen. I heard it." "You didn't stop her," she said. "No," I said. "Because if you had stopped her, the condition might still have been satisfiable," she said. "The painting might have been repaired." "Yes," I said. She was quiet again. "Edith, I want to ask you something directly." "Ask," I said. "Did you design the will with this outcome in mind?" "Not as the primary outcome, as the contingency that you believed was more likely than you acknowledged." I thought about this. "I designed the will to protect Noah," I said. "Either outcome protects Noah. The primary bequest protects him by keeping the property in a household where he lives. The contingency bequest protects him by putting the property in a trust that serves his specific interests." I considered both outcomes, and I concluded that both were acceptable. "You didn't answer the question," Catherine said. "No," I said. "I did not." She said, "I'm asking because I need to understand whether there is any aspect of how this has unfolded that requires us to address anything legally. If you believe you have in any way induced Clarissa to destroy the painting—" "I did nothing to induce her," I said. "I hung the painting where it had been since Noah gave it to me. I did not touch it. I did not say anything about it or to anyone about it. I was in the kitchen when she tore it." "And the original will is behind the painting," Catherine said. "Was behind the painting," I said, "in 4 pieces now, along with the painting." "The firm's copy and the bank copy are still intact," she said. "Yes, Edith," Catherine said. "I want to say something that is both legal advice and personal observation." "Say it," I said. "What you have done is entirely legal. The will is a valid document. The conditions are specific and verifiable. The outcome that is now in effect, the trust bequest, is exactly what the will specifies for this circumstance. There is nothing you need to do legally. When you die, I will conduct the estate examination. I will inquire about the painting. I will be told that the painting was destroyed, and the contingency bequest will take effect." "Yes," I said. "What I want to say personally," she said, "is that I think you are a woman who has thought very carefully about what is best for Noah, and that the design of this will reflect that thinking. And I think that Clarissa has, through her own action, confirmed the assessment underlying the contingency bequest." "Yes," I said again. "How are you?" she said. "I thought about the painting, about the house in 4 pieces and the sun in its corner and the flowers divided between the sections, about Noah making it in August with the care of a child who has decided something is important and who brings his full capacity to the importance." "I'm all right," I said. "The painting is in my drawer." "I'm keeping the pieces." "Of course you are," Catherine said. "That's exactly right. Noah came to my room on the Wednesday evening after the painting was torn. He knocked with the specific knock he uses for my door. 3 light taps, enough to announce but not enough to intrude. And I said, 'Come in,' and he came in and stood inside the door with the expression of a child who has noticed something, and who is something, and who is deciding whether to say what he has noticed. 'The painting is gone,' he said. 'Yes,' I said. 'Mom took it down,' he said. 'Yes,' I said. He came and sat on the edge of the bed, which is where he sits when we have conversations that require him to be settled. Well, oh wow. He has the quality of a child who manages proximity carefully, who chooses the right distance for each situation, and who adjusts it as the situation changes. 'Are you sad?' he said. 'I am,' I said. 'It was my favorite thing in the room.' 'I can make you another one,' he said. I looked at him. He meant it. The offer was genuine and not performative. The offer of a child who has a skill he can apply, and who applies it when application is appropriate. I would like that very much, I said. But not to replace this one. The one you made in August has its own meaning, and the meaning doesn't go away when the painting is torn. I'm keeping the pieces. He was quiet for a moment. Can I see them? He said. I got up and I went to the drawer and I retrieved the 4 pieces. I brought them to the bed and I spread them out. The house in 4 sections, with the garden and the door and the windows. The sun in the upper left corner of the largest piece. Noah looked at them for a long time. Then he reached out and he put the 4 pieces together, matching the torn edges with the careful attention of a child who has patience for puzzles. The painting came back together. Not perfectly. The tears showed. The pieces didn't align with seamless precision, but recognizably itself. The house was whole in the arrangement, even if the paper was not. It still looks like a house, he said. It does, I said. Does it matter that it's torn? He said. The picture doesn't change, I said. What you drew is still what you drew. The paper is damaged, but the drawing is what it is. He considered this. When things get broken, he said, are they still the same thing? Sometimes, I said. It depends on what the thing is. Some things are the same thing even when they're broken. Some things change when they break. Which is this, he said. This is the same, I said. You made a house for your grandmother. You still made it. That is still true. He nodded. He sat for a while longer, looking at the 4 pieces arranged on the bed. Then he said, Grandma. Yes, I said. Grandma. Yes, I said. I love you, he said. In case you didn't know. I know, I said. I love you too. Very much. In case you didn't know that either. I knew, he said. He got up. He kissed my cheek with the precision of a child who has learned where people prefer to be kissed, and who applies the learning. He went to the door. Grandma, he said from the doorway. Yes, I said. The new painting, he said. What should I put in it? I thought about it. A garden, I said. I have always liked gardens. He nodded seriously. He left. I put the 4 pieces back in the drawer under the winter sweaters. I thought about the will and about what would happen and about the trust that would hold the Chestnut Drive property for Noah until he was 25, and about the specific quality of a 25-year-old who grew up knowing that his grandmother's most treasured possession had been his painting, and that the painting had been protected, and that the protection had produced something for him. I thought about all of this, and I felt, in the way of a woman who has arranged things correctly and who can now wait, the specific piece of a decision well made. I want to tell you about the years between March 2024 and the winter of 2027, which was when I died, because those years are the years in which the story lived in its quiet form. Before the ending, before the estate examination, in the daily texture of a household that contained a secret that only I and Catherine Marsh knew. I lived in Patrick and Clarissa's house for 3 more years. The painting had been replaced on my wall, not by anything Clarissa provided, but by the new painting Noah made in April 2024, which he had worked on for 6 weeks, and which was, as I had requested, primarily a garden. The garden in Noah's painting had 3 flower beds and a path through the middle, and in the background, a house that was smaller than the one in the original painting, because the garden was now the main subject. He had signed it in the lower right corner, for Grandma, from Noah, age 8. He was still 8 when he made it. His birthday was in September, and he wanted the record to show what age he had been. The new painting went on the wall where the old one had been. It was a different painting in the obvious sense, and it was also a continuation of something that the original painting had established. Noah's specific way of thinking about what his grandmother needed, and his specific way of providing it. I looked at it every morning with the same pleasure I had looked at the original. Clarissa never asked about the first painting again. This was consistent with her approach to things she had decided were past. She moved forward from her decisions without revisiting them, which is in certain contexts a useful quality, and in this context was simply her nature operating in the way it always operated. She did not change. I want to be accurate about this, because the story could be told as one in which the grandmother's wisdom gradually brings the daughter-in-law to a different understanding, and that is not what happened. Clarissa remained who she was, efficient and stable, and managing her household with the competence she had always applied to it, and managing my presence in the household with the management she had always applied to me. There was no dramatic revelation, no gradual warming, no moment when she looked at Noah's painting on my wall and understood something she had not understood before. What there was? Noah, growing. He was 11 by the time I died, and he was the child he had always been with the additional depth that 11 provides. He continued to make paintings. He had settled into art as a sustained activity rather than a phase, the way some children do when they find the thing that allows them to be fully themselves. He gave me paintings when they felt right to give, and I hung them and looked at them in the mornings. Patrick and I had a relationship that deepened in those 3 years in the way that parent-child relationships sometimes deepen when time is visibly running out. He was not a bad son. He was a son who had organized his life around his wife's preferences in a way that limited his relationship with me. And in the last years he began, carefully and with the specific caution of someone who is navigating a household dynamic, he has helped create to be more present. We talked in the evenings sometimes, Patrick and I, when Clarissa was at her book club or at her sister's or otherwise occupied. We talked about Harrison and about the early years of Patrick's childhood and about the things that had happened and what they meant. We did not talk about the will. We did not talk about Clarissa. We talked about the things that were ours, the things that fathers and sons and mothers and sons share before the sharing is no longer possible. I was 86 when I died. It was a December, which is a reasonable month to leave. My health had been declining in the way of 86-year-old health, not dramatically but specifically, and I had been expecting the ending without knowing its exact form. It came in the way I would have chosen if choosing had been available. At home, in the room with Noah's garden painting on the wall, not in a hospital. The painting was the last thing I saw before I slept for the last time. The garden with the 3 flower beds and the path and the small house in the background. Signed by Noah, age 8, when the year was still spring and everything was possible. Catherine Marsh conducted the estate examination in January, 6 weeks after my death. She had the will from the firm's files and the bank copy for reference, and she arrived at the house on a Thursday morning with the specific manner of someone who has done this many times, and who knows that estate examinations are always both procedural and profoundly personal. She asked to speak with Patrick and Clarissa together, which was the standard practice for the primary beneficiaries. They sat at the kitchen table, the kitchen where I had had my tea on the Tuesday morning when the first painting was torn, the kitchen where I had had my tea on 1,000 mornings since. And Catherine opened the file. "I want to explain the structure of the will before we discuss any specific provisions," she said. "There are conditions attached to the primary residential bequest. The conditions require verification before the bequest can take effect." Patrick said, "What kind of conditions?" "The property at 4,421 Chestnut Drive." Catherine said, "Is left conditionally. The condition for the primary bequest is the existence of a specific item in the household at the time of Edith's death. The condition for the secondary bequest is the absence of that item." "What item?" Clarissa said. Catherine read the condition from the will in its full legal language. Clarissa was very still by the end of the reading. "The painting," Patrick said. He had understood more quickly than his wife, which was not typical. "Noah's painting. The one he gave Mom last September." "The one from 2023, Catherine said. "Yes, it's on the wall," Patrick said. "In Mom's room. He stopped. "The second one." "Noah made a second one. There are 2 paintings." Catherine said, "Mom hung the first one in September 2023. Patrick said slowly. Then it came down. Then Noah made a second one in April 24. The second one is in Mom's room. Catherine looked at the will. The will specifies the painting given at the testator's birthday celebration in September 2023. The second painting would not satisfy the condition for the primary bequest. Clarissa said the first one. Yes, Catherine said. The painting from September 2023. Do you have it? Clarissa looked at Patrick. Then she looked at the table. The first painting, she said, came off the wall in March 24. What happened to it? Catherine said. Patrick looked at Clarissa. I know this from what he told me later. Patrick told me many things, in the specific way that people tell the person who has died things they need to say, in the quiet of a room that still holds the specific absence of that person. He looked at Clarissa and he understood in the specific way of someone who has been not looking at something for 3 years and who is now looking at it clearly, what had happened. Clarissa, Patrick said. She said nothing. What happened to the painting, he said. Catherine Marsh, who has conducted many estate examinations and who has observed many family moments of the kind that estate examinations produce, waited with the patience of someone who knows that patience is what the moment requires. I thought it was... Clarissa stopped. I thought it was just a child's drawing. I didn't know it had anything to do with... Where is it now? Catherine said. I tore it. Clarissa said. In March 2044. Patrick was quiet. Catherine said. The condition of the primary bequest has not been satisfied. The secondary bequest takes effect. The Chestnut Drive property transferred to a trust in Noah's name. The trust was administered by a professional trustee from a Columbus firm that Catherine had recommended, not Franklin County Children's Services, which was named in the will as the default option, but which Catherine and I had discussed and agreed could be replaced by a private professional trustee who would serve Noah's interests with the same accountability. The trustee was a woman named Priscilla Howarth, who had administered educational trusts for 30 years, and who had, in Catherine's assessment, exactly the combination of financial expertise and genuine concern for the beneficiary's welfare that the situation required. The trust's terms were specific. The income from the property, which would be rented until Noah reached 25, was to be used for Noah's education and welfare in a schedule managed by the trustee in consultation with Patrick. Noah's interest was primary. The trustee had the authority to override other claims on the trust if Noah's interests required it. The property itself, at 25, would transfer outright to Noah. He would be free to do with it what he chose. The conversations that happened in Patrick and Clarissa's house in the weeks after the estate examination are not mine to reproduce, because I was not there for them. I know from Sarah, my daughter, who came from Portland for the estate process and who was the sibling executor alongside Patrick, that the conversations were difficult. Sarah said it was the most honest Patrick had been with Clarissa in 20 years. She said it without satisfaction, which is the correct way to say something like that. What I know from other sources, from Catherine, who was there for the legal process, and from Noah, who told me things in the way that children who are paying attention tell the people they trust, is the following. Noah was told about the trust when he was 12, in the spring. Patrick sat with him and told him clearly and in full what the will had said and what the painting had meant and what had happened. Noah listened in the way he always listened to important things, quietly, with full attention, asking questions, at the pauses that told him more was available to ask about. He asked, "Grandma put the will behind my painting?" Patrick said yes. He asked, "Because the painting was the most important thing." Patrick said, "Because the painting was the most important thing to her, and she wanted the most important thing to protect the most important document." Noah was quiet for a moment. Noah was quiet for a moment. Then he said, "I'm glad she had the painting for as long as she did." He said it with the specific quality of a 12-year-old who has arrived through a sideways route at exactly the right conclusion. Patrick said, "She looked at it every morning." "I know," Noah said. "She told me. I want to tell you about Clarissa, because the honest account requires it. And because honesty about Clarissa is more complex than either the sympathetic or the unsympathetic version. She was not destroyed. I want to say this clearly, because the story could be told as one in which the daughter-in-law's impulsiveness leaves her destitute. And that is not what happened." Patrick's income continued. Their household continued. The loss was the Chestnut Drive property, which had been significant in their expectations, but which had never been their only resource, and their life absorbed the loss the way households absorb the losses that are significant but not catastrophic. What she lost that was harder to absorb was something else. In the months after the estate examination, she came to understand what she had done. Not through the legal process, which was clinical and specific, but through the experience of living with Patrick, who understood what she had done, and who did not, in the months after the estate examination, pretend that he did not understand it. She had torn a painting that her son had made for his grandmother. She had done it because she found the painting an aesthetic irritant, and because she had not considered the possibility that what looked like a child's drawing might be connected to anything else. She had done it in a moment of the kind of casual contempt that people who hold power in a household can exercise toward the things and people they regard as not meriting respect. The consequence of this action was the loss of the property. But the consequence beneath the consequence, the one that was harder to locate and harder to address, was what the action said about her relationship to her son. Not a painting that belonged to the household. A painting her son had made for his grandmother with the care and intention of a child who understood that making something for someone was the most genuine form of giving. Noah knew this. He did not say it to her directly. He was 12 when he found out, and he processed it with the same quiet patience with which he processed everything. But the knowledge was in the space between them, and Clarissa could feel it there. She tried, in the years that followed, to understand her son better. She asked him about his paintings and attended to the answers. She came to the school art show in November of his 7th grade year, and she stayed for the full event, which was more than she had done for the previous shows. She said things that were not well said because she did not have the vocabulary for this kind of engagement, and had to find it. But she said them with something that looked like genuine intention. Noah received this. He is not a person who holds permanent accounts. He is a person who pays attention to what is happening now and responds to what is happening now. And what was happening now was his mother trying to do something she had not previously tried, and he responded to the trying. They are not the people they might have been if the painting had not been torn. But they are not the people they were before it either. The tear in the painting produced in the family a different kind of tear, the kind that opens rather than destroys, that creates space for something other than what was there before. I did not plan for this, but I am glad of it. Noah is 17 now. He has been accepted to the Columbus College of Art and Design, which is the school he wanted and which is appropriate for who he has become. A young man who makes things with his hands and his eyes and his particular way of attending to the world, and who has found in art the specific form of expression that allows him to be most fully himself. The Chestnut Drive property will transfer to him when he is 25. He knows this, and he has thought about it. He told Patrick that he intends to live in it, that he wants to maintain the garden, that he has been thinking about what a house means to a person who grew up knowing that a house his grandmother owned, his grandmother owned, had been set aside for him because of a painting he made when he was 8. He asked Patrick once in the quiet, direct way of Noah's serious questions, "Did Grandma know what would happen when she put the will behind the painting?" Patrick had thought about this. "I think," he said, "that she knew what might happen. She didn't know what would, But she designed it so that either way was all right, Noah said. That sounds right, Patrick said. That's a good way to design things, Noah said, so that either way is all right. He has made paintings for me since I died. He hangs them in his room in the place where I can see them, which is everywhere and nowhere, which is the specific location of the things that persist after the person who held them is gone. The first painting, the original from September 2023, is in 4 pieces in an envelope that Patrick keeps in his desk. He retrieved the pieces from the drawer under the winter sweaters when he cleared my room, and he understood what they were, and he kept them. He has not told Clarissa he kept them. He keeps them the way people keep things they need to keep, for reasons that are not entirely articulable. Catherine Marsh told me, before I died, in one of the last conversations we had, that she believed the will would be remembered as one of the more elegant estate instruments she had drafted, not because of its financial structure, which was straightforward, because of the thing it had discovered about the person it was designed to discover it about. The will tested whether Clarissa would protect the painting, Catherine had said. And the answer told you what you needed to know about whether she would protect Noah. Yes, I had said. She failed the test, Catherine had said. But Noah has the house. Noah has the house, I had said. And he will know, when he moves into it, why he has it. And the knowing will be part of what he carries into it. The knowing is the inheritance that matters. My name was Edith Marion Caldwell Prescott. I was a paralegal for 26 years, and I was a wife and a mother and a grandmother, and I loved a child enough to design something that would protect him regardless of how people chose to behave, and the design worked as it was designed to work. And the child has the house. The painting in 4 pieces is in an envelope in his father's desk. The new painting from April 2024 is still in the room where I hung it. Patrick has kept the room as I left it. He has told Noah that the room will be Noah's when he comes home from art school, which seems right. The garden at Chestnut Drive will need attention in the spring. It has been rented for the past 3 years, and the tenants have been adequate stewards but not attentive gardeners, and there will be work to do when Noah takes over. He will do the work. He is the kind of person who does.